If one party to a contract wants to make the other party do something, but accepts that for whatever reason it can't be an absolute obligation, then there are 4 ways that this obligation is commonly expressed. I put them up on the slide and you'll see that it's basically X will endeavour to do it, X will use its reasonable endeavours to do it, X will use all reasonable endeavours to do it, or X will use its best endeavours to do it. Although these are the most common permutations of the endeavours obligation, clients and I think lawyers alike still get confused as to what each one means, when each one should be used, and indeed what the difference is between them. The reason for this is that every time we think we know what they mean, a new case comes along and the courts add some new gloss or twist. But this isn't because the courts are uncertain or capricious, it's because what an endeavours obligation actually requires in any given case depends on both the other provisions of the contract and on the surrounding commercial context. In recent years, we've had the CEP Holdings and the CPC group cases, and then last year we had the Jet2.com case, and I've given the references for all 3 cases on this slide for those who want them. So before we get into the Jet2 case, what can we say with certainty about these obligations? Our starting point, although it should go without saying I suppose, is that none of these are absolute obligations. So if whatever X we're supposed to be trying to achieve doesn't happen, X will always be able to argue that he complied with his contractual obligations. And so it's worth considering whether the obligation should be expressed as an absolute obligation, even if X can't be certain of achieving it. The endeavours obligation shouldn't be a substitute for the role of a force majeure clause. For example, if I want my house painted, I expect the painter to say that he will paint it, not that he will try to paint it. On the other hand, I accept that if there's a thunderstorm raging, he's not going to be up a ladder priming my barge board. So in this example, an absolute obligation coupled with a force majeure provision is appropriate in the contract, rather than an endeavours obligation. The second thing we can say is that, ignoring for a moment what each expression means and the extent of the differences between them, the order in which I've set them out on the previous slide has traditionally been accepted as the order of ascending obligation. So best endeavours is the highest obligation short of an absolute obligation. So against that background, let's move to look at the Jet2 case. This case is probably most interesting for its illustration of the principle that what an endeavours obligation actually requires in any given case depends on both the other provisions of the contract and on the surrounding commercial context. The parties have both best endeavours and all reasonable endeavours obligations in the contract, and the judge was clear that the meaning of these expressions was a matter of contract interpretation, and the meaning was not to be determined by extrapolation from other cases. So here is a clear practical pointer from the courts. There will be an inherent uncertainty as to what an endeavours obligation may actually require in any given case, and so if there are particular steps which a party will be expected to carry out to try to achieve the desired results, ideally they should be specified in the contract. So, for example, assuming I've now relaxed my attitude towards my painter, our contract could say the painter will endeavour to complete the painting of Jonathan's house by the end of January, including by prioritising this work over any other work, having a minimum of 2 painters on site from 8 AM to 4 PM daily, etc., etc. Now, turning to the expressions themselves, X will endeavour to and X will use its reasonable endeavours to can be easily dealt with because in fact they mean the same thing. Logically, X only endeavouring to do something to the extent that it's reasonable to do so is the least stringent obligation, and X will endeavour to can't imply that X will use any more or any less endeavours than those which are reasonable in the circumstances. As I mentioned earlier, reasonable endeavours, all reasonable endeavours and best endeavours then represent the spectrum in ascending order of obligation. But you may ask, if we can't know with certainty what any of these obligations requires in any particular case, how do we know that they do actually represent that ascending order of obligation? And that's a fair question. The second interesting point from the Jet2 case is that although the contract contained, as I say, both a best endeavours obligation and a separate all reasonable endeavours obligation, the parties in that case actually agreed that in their contract these 2 expressions meant the same thing, and so the judge treated them as interchangeable. Nevertheless, there is some guidance from previous cases as to the principles relevant to the interpretation of these expressions, even if the interpretation in any particular case is going to be context specific. So let's distill those down. The starting point for best endeavours is Sheffield District Railway and Great Central Railway. It means what the words say. They do not mean second best endeavours. Moving on to IBM UK and Rockware Glass. The party under the obligation is to take all those steps in their power which are capable of producing the desired results, being steps which a prudent, determined and reasonable person acting in his own interests and desiring to achieve that result would take. Note the reference there to a reasonable person in the IBM case. What does this mean? Two practical illustrations on that. While best endeavours may require money to be spent trying to achieve the aim, the party may have some regard for its own commercial interests and is not required to take action which would result in the certain ruin of the company or the utter disregard for the interests of its shareholders. That's from Tyrrell and maybe Todd. And similarly, a best endeavours obligation may impose an obligation to litigate or appeal against a decision, but would not extend to an action that was doomed to failure or would be unreasonable in all the circumstances, and that's Malik and Central European Trading Agency. Turning to reasonable endeavours, there are a couple of different formulations. First, it involves the obliger balancing the weight of their contractual obligation to the other party against all relevant commercial considerations, and in doing so, the chances of achieving the desired result are also of prime importance, from UBH Mechanical Services and Standard Life. And then it's based on the circumstances of the obligor, and the obligor is not required to sacrifice its own commercial interests, P&O Property Holdings and Norwich Union. Finally, the suggestion that it only takes the party a requirement to undertake one reasonable course of action rather than many, and that this is the limiting element that may distinguish it from an all reasonable endeavours obligation, Rodier and Huntsman. And then on to all reasonable endeavours. This is probably the trickiest of the three expressions to define, and yet paradoxically, it may be the most commonly used, because parties view it as the compromise between reasonable endeavours and best endeavours. To the extent it doesn't denote anything more than best endeavours or anything less than reasonable endeavours, that compromise solution view is probably correct, and the courts have sometimes gone with this. As you'll see on the slide there, it's probably a middle position somewhere between the two, implying something more than reasonable endeavours but less than best endeavours, UBH and Standard Life. But whether it will actually be any different from reasonable endeavours on the one hand or best endeavours on the other hand in any particular case is another matter. For example, in Rodier and Huntsman, the court said that an obligation to use reasonable endeavours to achieve the aim probably only requires a party to take one reasonable course, not all of them, whereas an obligation to use best endeavours probably requires a party to take all the reasonable courses he can. In that context, it may well be that an obligation to use all reasonable endeavours equates with using best endeavours. And then we have last year's Jet 2 case, with the parties agreeing that in their contract, best endeavours and all reasonable endeavours meant the same thing. So now we can properly put the Jet 2 case in context. The judge's statement that the meaning of these expressions is a matter of contract interpretation, and the meaning is not determined by extrapolation from other cases, represents the high watermark, if you like, for an inherent uncertainty of meaning in the use of these expressions. One more significant element in the Jet 2 case, and for that we need to look at the facts of the case. Jet 2 is a budget airline. It had a 15-year contract for flights in and out of Blackpool Airport, under which both parties would use their best endeavours to promote Jet 2's flights from Blackpool Airport, and the airport was to use all reasonable endeavours to provide a low-cost base to facilitate Jet 2's low-cost pricing. One of the ways that Jet 2 achieved its low-cost pricing was to schedule flights outside of the airport's normal opening hours. This meant that the airport had to stay open beyond its usual closing time, and sometimes just for one Jet 2 flight. And for the first 4 years of the contract, the airport ran at a loss. The airport then refused to accept arrivals or departures scheduled outside its normal hours and gave Jet 2 1 week's notice to change its schedules. Jet 2 sued for breach of contract and won. The court said that the airport was not entitled to take this action to protect its commercial interests. But remember the Tyrrell and Maybe Todd case, which said that while best endeavours may require money to be spent trying to achieve the aim, the party may have some regard for its own commercial interests and is not required to take action which would result in the certain ruin of the company or the utter disregard for the interests of shareholders. But in the Jet 2 case, the court said that the airport could not pick and choose what to do in the light of what suited it financially. The fact it had been losing money since the start of the contract reflected on its own competence and cost effectiveness, but these were risks which one would assume the airport alone would bear in a commercial contract. The actions that the airport could take, supporting the scheduling of flights outside its normal opening hours, were entirely within its control, and so could be distinguished in this respect from, for example, an obligation to pay an extortionate price to achieve a result beyond its control. If the court was to accept this limitation on the obligation, it would in effect grant the airport the ultimate exclusion clause. So the third significant point on the Jet 2 case is the relevance of the consideration of the party's own commercial interests in determining the extent of an all reasonable endeavours obligation. Finally, the Jet 2 case not only demonstrates the inherent uncertainty as to what an endeavours obligation may actually require in any given case, but also the practical issue that I described, that if there are particular steps which a party is expected to carry out to try to achieve the desired result, ideally they should be specified in the contract, because although the court found that the airport was in breach of contract by refusing to schedule flights outside its normal opening hours, it admitted that it couldn't set the parameters on the all reasonable endeavours obligation. So, for example, if Jet 2 wanted to schedule all of its flights between, say, midnight and 4 a.m., the court couldn't say that it had the right to do so simply by virtue of the airport's all reasonable endeavours obligation to facilitate Jet 2's low-cost pricing. So in conclusion, if your draft contract says use all reasonable endeavours, think about changing that to all reasonable endeavours including, and then specify those actions that you know now that you will want the other party to take. So that concludes the endeavours presentation. I'll now hand over to Alex Beale for our third patient. Alex.